Good morning, good afternoon, good evening, everyone. Thank you for attending this fifth webinar of the 2021 webinar series, which is dedicated to oil spill preparedness and response. The total durations of today's session will be 75 minutes. And I will start by introducing myself and today's team. So my name is Chloe Gondo. I am GI WACAF Project Coordinator, and I'll be facilitating this webinar today. Today's speakers include Untitled, who is Senior Legal Advisor at IMO. Hi, Jan.
Hello.
We also have Chiara Della Mea, who's Claims Manager at IOPC Funds. Hi, Chiara.
Yeah. Hi.
And David Baker, Emergency Preparedness and Response Advisor at IGP&I Clubs. Hi, David.
Hi, Chloe. Hi, everybody.
Let me also introduce you to Lindsay Page-Jones, who is the new GI WACAF Project Manager. Hi, Lindsay.
Hello, thank you, Chloe. Good afternoon, everybody. Thank you to attend to this webinar. So I'm Lindsay Page-Jones, the new interim GI WACAF Project Manager since mid-September this year. So please be aware that we are looking for candidates for this position, starting from the beginning of next year. And you have the job offer available on the website of the project, giwacaf.net, in the news section. Thank you very much, and enjoy the webinar.
Thank you, Lindsay. Thank you, presenters. You can now all turn your videos and microphones off. While participants are joining, I'll provide you with some technical information details regarding this webinar platform. So first of all, you can access a chat box where you can ask questions that will answer at the end of the webinar during a dedicated Q&A session. This chat box is normally on the left side of your screen, right side, I'm sorry, of your screen. You above where you type your message, you also have documents and PDF presentations that will be made available for download during this webinar. If you have any connection or internet problems, you can reconnect by clicking on the red button that's called reconnect at the top of your screen. And be aware that all webinars organized by the GI WACAF projects are available in replay on our website and YouTube channel. So let me share with you the first presentation. Here we go. So after a first series of webinars organized last year on the main principle and general framework of oil spill preparedness and response, of which, again, you can find all the videos and replays on our website. This second series will focus on slightly more specific and technical subjects. For those of you who did not attend the first series of webinars or who may be not familiar with the GI WACAF project, let me first give you a brief introduction to the project before introducing today's webinar. So GI WACAF stands for the Global Initiative for West, Central and Southern Africa. The project was launched in 2006 in the framework of the Global Initiative by IMO and IPCA. IMO being the International Maritime Organization. So this is this UN specialized agency which is responsible for navigation safety and the protection of the marine environment. And IPCA is the Oil and Gas Industry Association for improving social and environmental performance. The GI WACAF project is really a collaboration between the industry and governments in line with the IOPC 90 Convention. The objective of the project being to enhance the capacity of the 22 partners countries in Africa that you can see on the map to prepare for or respond to oil spills so that they can better protect their marine and coastal environment and communities. And to do so, the GI WACAF Project organizes activities such as national or sub-regional workshops, trainings, exercises, and conferences. So this is, in a nutshell, what the project is and what it is doing. Again, it's a joint endeavor of the public and private sectors to manage all spill risk and mitigate associated impacts. It supports 22 African partner countries. The purpose is really to maintain constant liaison with partner countries and in the industry. The project also encourages better communication and collaboration between governments and industry, and it encourages partner countries to ratify and implement international conventions, relevant convention. So building on the first season of GI WACAF webinar series, which ran from June to December last year, and this new series this year, started in April, covers more specific topics of oil spill preparedness and response. Today's webinar is the 5th episode, and it is dedicated to the international liability and compensation regime. And please note that there is twin episode that is going to be held in 2 weeks' time. So Wednesday, October the 13th, which is going to be on how to claim for compensation in case of an oil spill. And you can already register to this webinar via our website. The objectives of the webinar today are for you to understand the scope and implementation of the IMO Conventions relating to liability and compensation, and also get an overview of the functioning of both the IOPC funds and IGP&I clubs, since you will meet representatives from these entities in over the course of this webinar. To do so, I have with me today three presenters, who will deliver 3 presentations of about 15 minutes each. The first presentation will be an introduction to the IMO Civil Liability and Compensation Conventions. The second presentation will be on the 1992 CRC and Fund Conventions. And the last presentation will be on the 2001 Bunkers Convention, as well as the 1976 LLMC Convention and Protocol. Thank you very much for listening to me. You can find all information that you need on the GI WACAF project throughout on the website and also on our LinkedIn page. There's also a brochure that is already available to download above the chat box. And now we'll give the floor to Jan for the first presentation. Thank you.
Thank you, Chloe, for your introduction remarks and also for explaining what to expect. Yeah, my role is to enlighten you about the principles of the IMO Civil Liability and Compensation Conventions. And in order to do that, I will share my screen in order to present what is going to be my presentation. And I put it here. I hope in presentation mode. Yes. So I will also highlight somewhat about the structure of IMO, because the convention that we are dealing with this afternoon is about IMO conventions. So, but let me take you first back to 19 1967, and it takes a while to go there because now there we go. 1967 took a while. There was actually the first major oil pollution incident with an oil tanker carrying crude oil, the Torrey Canyon, which stranded off the coast of Great Britain and France. And actually, it was just outside of the territorial waters of Great Britain. But the size of the pollution was that big that also the coastline of France was really under threat. So this was the first time that the international maritime community was actually confronted with a major calamity on a scale that had not been seen before, and dealing with oil pollution. It was evidently that there was need for regulation because it was a ship located outside of the territorial waters. So little was known about which rules would apply to compensation, and actually also about what measures would be most feasible to take. There was a lot of controversy about that, and also of the right actually of the coastal states to intervene. So in 1969, two conventions were adopted in the International Diplomatic Conference, which were the International Convention on Civil Liability for Oil Pollution Damage, and also the Intervention Convention. But first, the 1969 Civil Liability Convention. It's a major convention in the sense that many conventions that were later being adopted in the same field of liability compensation were actually footed on the same principles of this convention. And to name a few, these conventions for the first time made the ship owner strictly liable for damage caused by the spills of crude oils. This was the cargo, which means that you don't have to prove fault. And this strict liability was accompanied by a compulsory third-party liability insurance up to some limits. These limits were set quite high, actually, to provide for the necessary guarantees that compensation to be expected would be compensated. In order to attest that this insurance is enforced, the convention provides that a certificate needs to be taken on board, and in order to provide for a harmonized implementation, there's a model form actually attached to this convention. I mention this because this certification is not only relevant for the original 1969 Civil Liability Convention, but all IMO liability conventions dealing with compensation adopted after this major convention. One of the specifics further is that direct action is possible. Not only compensation can be claimed directly from the ship owner, but also from the insurer of the ship owner. And actually, this direct action provides that the insurer needs to provide for a guarantee that's directly accessible in courts. So what is needed for implementation of this convention and all the other conventions adopted later on is that national courts need to possess necessary jurisdiction. That's quite important in these conventions regarding implementation, but also certificates need to be carried on board, but have also to be issued according to the standards. That's also an important feature for the implementation of this convention. But that's dealing with the Civil Liability Convention. as already mentioned, the Torrey Canyon stranded outside of the territorial sea, and because there were no rules for intervention, also in 1969 the Intervention Convention was adopted at the same conference, dealing with public measures, providing legal powers for the coastal state to intervene in the waters beyond the territorial sea in cases of severe oil pollution damage caused by ships. Well, I like, as I explained, to highlight the role of IMO in this context of the major calamities, because the mission of IMO is to provide for safe, secure, and efficient shipping on clean oceans. But I further would like to illustrate that 90% of global trade is carried out by ships. And because management and ownership of ships embrace many countries, and ships besides of that spend many their lifetime actually between different jurisdictions, often outside of the state of registry or where all the management offices are being located. It demonstrates that there is definitely a need for international standards. Actually, without international harmonized standards, shipping would be very difficult, because ships seems to be located all over the world. So IMO is providing for this kind of regulation on international harmonized level, and it's the only UN agency headquartered in London. It has a low budget comparatively with the other United Nations institutions, of about £30 million a year. A very limited number of staff, 265 staff, and it actually is the philosophy that all the work undertaken in IMO is undertaken by the member states. So it's the countries actually that implement all the conventions, and the Secretariat is facilitating the member states. There are about 50 nationalities in the staff, makes it a truly international organization with 174 member states, which include all nations which show interest in maritime affairs. So it was not without reason that after the Torrey Canyon, the assistance was being sought of the International Maritime Consultative Organization, as it then was being called, which later became the International Maritime Organization. So first, the 69 Civil Liability Convention was established, with civil liability and with compulsory insurance. But already at the time of the conference, it was foreseen that there would even be a need for further funds for compensation provided by a supplementary 71 fund, was adopted in 1971, providing for additional compensation in case the limits of liability of the ship owner would provide not to be sufficient. 69, also the Intervention Convention was established, but that was only for oil. So in 73, there was a further protocol being adopted also to relate to other substances that can be dangerous, hazardous, noxious substances other than oil products. Then the IMO legal committee, which was established by the Torrey Canyon, undertook further work to harmonize rules on limitation of liability. And I mentioned that in particular because this convention, that was adopted in 1976, plays an important role relating to other instruments like the Nairobi Wreck Removal Convention, but also the 2001 Bunkers Convention, that do not provide for their own limits, but relate to the generic limits as established by the 76 Convention. And in 1996, the limits were increased quite substantially. And I think that David Baker, in his presentation later on, will further explain about how these conventions interrelate with the Bunkers Convention and also the Nairobi Vacuum Removal Convention. Because in 1969 limits were established, which after 20 years proved not to be sufficient when there was a major oil spill in France with the IMO Conventions. In 1984, protocols were established dealing with increased limits of the Civil Liability Convention, but also the Fund Convention. But this convention in 84 did not come into force because it was being expected that the United States of America would become party. But apparently they had chosen their own system of liability compensation, the Oil Pollution Act. So when that became clear in 1992, new protocols were adopted to the Civil Liability Convention and the Fund Convention, which came into force later, but had lower entry into force conditions. So that was actually needed to change that in 92 on the basis of the 84 protocols to allow for an entry into force without the United States of America. Meanwhile, in 1989, a convention was adopted in IMO dealing with assistance and salvage, and that's quite an important feature besides of the liability convention, because as long as a ship owner considers that the cargo also after an incident is still on board and presents a value, and the ship itself, it might be better off to have this ship being taken into security, safety by own commercial means. So there's a kind of interface of the commercial contracts regarding salvage and the application of the IMO compensation and limit liability conventions. In 1996, there was, after 3 attempts, because already in 1969 it was actually being considered that not only oil pollution but also hazardous noxious substances could give rise to pollution damage that needs to be compensated. It was then agreed to have that being adopted by a conference which took place in 1984, besides of the increase of the limits of liability of the 1992 protocol, then became the 1984 protocols. It was then foreseen to have also a convention on HNS, on hazardous and noxious substances. But that attempt in 1984 failed because it was not foreseen how to set up a additional fund like with the oil pollution cases. So in 1996, a third attempt actually was being undertaken to establish that regime. I come to that because that's the only convention that has not come into force of all the conventions that we are dealing with today. However, in 2001, just dealing with compensation for claims relating to the bunkers of ships, so not when the oil is carried as cargo, but carried as bunker fuel. A separate regime was needed because that was not covered under the 1969 or the 1992 Civil Liability Conventions, unless there was a dedicated oil tanker causing the pollution by the bunkers. But apart from that, all ships that do have large quantities of bunker fuels on board are under the 2001 convention being obliged to have also compulsory insurance on board and are exposed to liability by the member state in which the oil pollution takes place. In 2003, a protocol was adopted in addition to the regime of oil pollution established by the 1992 Civil Liability Convention, and the protocols of 92 also increased the amounts of compensation under the 1992 fund. So in 2003, an additional fund was actually being established because of the consequences of the Erika incident. And because of this 2003 protocol, there is up to $1 billion available for compensation. Another issue, which was actually already contemplated in 1969 during the diplomatic conference of the Torrey Canyon, in 2007, finally, the convention was adopted on wreck removal in Nairobi, which is called the Nairobi International Convention on the Removal of Wrecks. It's also dealing with liability intervention, also dealing with threats caused by oils still on board wrecks. And actually, it can be an alternative also when it is about removal of bunkers. But time is not permitting to dwell too much on that. In 2010, finally, a protocol was adopted to actually make it more feasible to have the HNS convention that was adopted in 1996 to come into force. But I will explain that because that's a major piece in the puzzle of liability, which we still have to finalize. Now, we'll lead this too with some of the participating states at the current situation. As you can see from my slide, in the field of liability relating to oil pollution by dedicated oil tankers, you see that Angola, Cameroon, Ghana, Liberia, Namibia, Nigeria, and South Africa. I understand that those countries are most represented by the participants. They all have actually implemented or ratified the Civil Liability Convention of 92, but also the Fund Protocol. So you see that field is quite covered. When it comes to the bunker fuels, we see that Liberia, Namibia, and Nigeria have already ratified, but there are still some gaps in West Africa. From the states that have ratified the 76, that's I wanted to come to the limitation conventions, Liberia and Nigeria, who have actually general limits, and Liberia is also party to that protocol. And then you see that there's also further work needed on the wreck removal and salvage. And HNS, you see Angola and Liberia have ratified the original 96, but that will not come into force. It will be the HNS protocol of 2010 that is now ratified by South Africa. And I want to tell you somewhat more about HNS because it is the last convention that still needs to come into force. So in 2010, this protocol was adopted, by which the 96 HNS convention was renamed in the 2010 HNS convention. It will come into force after ratification by 12 states. But also it's important to have 40 million of contributing HNS cargo, which contributes to the supplementary layer. It's a similar regime as the oil pollution, established by two conventions, ship owner liability and the supplementary layer by contribution from the oil industry. But that same principle is now for hazardous noxious substances being included in this one single HNS convention. It has a robust solution for all the issues that were encountered under the 96 convention, but doesn't come into force. So there are no contributions by containers. Reporting is facilitated, and all substances actually, in principle, are being based on the same footing, also for LNG, LPG, hazardous solids, solid bulk substances, and also liquid bulk substances. The convention was signed by 8 states: Canada, Denmark, France, Germany, Greece, the Netherlands, Norway, and Turkey. But it was subject to ratification. But as it is now today, Norway, Canada, Turkey, Denmark, and South Africa have ratified the convention, which means that there's a need for 7 more countries to ratify. But there's good news on the way, because of the states that originally signed. Germany, the Netherlands are close to ratification, together with Belgium and Sweden. So also the 14 million of contributing HNS cargo which is needed will actually be delivered by those states that are now working on ratification. So it's expected that it will enter into force soon. I give you an example of the HNS Convention also for some leading principles of damage, which are shared also by the other convention, but not for all kinds of damage. In the definition of damage under the HNS Convention, it started personal damage, but personal damage is actually so to human life being recognized only in the HNS Convention and not under the Civil Liability Convention dealing with oil and the bunker fuels, and also not under the Nairobi Convention. Though that aspect is quite important. But then property damage, that is actually a concept under the HNS, which is also shared by the other conventions. Same can be said of reasonable measures of reinstatement. Damage by contamination of the environment is restricted to those reasonable measures of reinstatement, actually to not include arbitrary made decisions what counts for pollution damage. So not to be based on forfeitary calculation models, but really about feasible and reasonable costs which are undertaken or to be undertaken. And that includes also cost of preventive measures. The conventions, the Civil Liability Convention, FUND, the Bunkers Convention, the Nairobi Wreck Removal Convention, and also the HNS Convention are all based on the concept of strict liability. So you don't have to prove fault. It's very straightforward, no lengthy court proceedings. So it guarantees prompt and adequate compensation. It's from the start known who's liable, it's the registered ship owner. Only in the Bunkers Convention you can also have claims to the to the charterer and to other who are called managers of ships and ship owners other than the registered ship owners. But in general, the channel of liability is quite streamlined in all this convention in order to safeguard operability. All the conventions accept that there's a limitation of liability, and it is not to give precedence to the ship owner, but it's all based on expectations, what kind of damage you might expect, and that are then also insurance, because the insurance has to be orchestrated and has to be built up on foreseeability of those damage. So the figures of these limits are actually set on reasonable heights of expectations of damage. And actually, in case ship owner liability up to the limits is not sufficient, funds are foreseen providing for supplementary compensation. I think this is in a nutshell where it's all about in the field of liability compensation by the IMO Convention. I have now a particular section, and I don't know whether I can continue. I would like to ask
Thank you very much, Jan, for your very interesting presentation. I think we'll leave the questions for now and let Chiara present, And if we have time at the end of the webinar, we will come back to your quiz for the audience, if you don't mind.
Okay, that's fine. So then I stop sharing and I give the floor back to you, Chloe.
Thank you very much, Jan. To the participants, if you have questions for Jan, please leave them in the chat box right now, and we'll answer them by the end of the webinar. Thank you very much, Jan, and Chiara, the floor is yours.
Okay, thank you, and I'll see what I can do without. I'll try not to go too much over time. Let me see. Okay, Jan has already talked about the CLC and fund convention in some details, so I'm only going to focus on some points, which I think they're worth focusing a bit more. But first of all, like was said before, the CLC and fund, it's different conventions, 3 different conventions, but they provide a single regime for compensation for oil pollution damage. In particular, the 92 Fund Convention and the Supplementary Fund Protocol create 2 intergovernmental organizations, which is the 92 Fund, the Supplementary Fund. These organizations are governed by member states, and they're administered by Secretariat, and I am part of that Secretariat, which is why I'm talking about it. What is important about this system is that what the system does is ensure uniform application of the compensation regime throughout the world. So the criteria that are used to assess claims, to deal with incidents, are the same in all member states. There is a certainty of law, in a way, at the global level. And it also ensures that all the claimants are treated the same, which means that we don't assess claims on the first come, first serve. All the claimants are assessed based on the same criteria, and we're going to talk more about this criteria in the next webinar. But it's also important because if there is not enough compensation available for all, this also means that all the claimants will receive the same amount, the same proportion of their claiming compensation, but nobody will be left without. Like I said, it provides compensation to victims of pollution damage. The idea following the Torrey Canyon was to create a system by which the victims of pollution damage did not have to go to court to receive compensation. So the underlying concept is that compensation is given through amicable settlement without going to court, without having additional expenses for the ones who already suffered the loss. It covers pollution damage caused by spills of persistent oil from tankers, not just by spill of the cargo, but also spill of bunkers if the tanker is in ballast. And it also provides compensation, at least the fund of convention provides compensation for spill from tankers when you cannot identify the tanker, for as long as you can identify that it was a ship as per the convention. And it applies to the territorial waters and exclusive economic zone of the member states. Sorry, just it's not going forward. Just a moment. I don't, Chloe, I don't know if you can help me. Oh, the guy's moving now. So this is just, can you go back one? Sorry, don't know what happened. It's got, can you, thank you. Okay, very quickly, apologies for this. It's technical issues as usual. Oh, back one, please. There are a number of, obviously, any loss or damage that is caused by the contamination, for as long as it's a reasonable loss, it is admissible for compensation. In the history of the fund, we have found that normally claims can be categorized in different sectors. Obviously, there are claims for cleanup and preventive measure. There are claims for economic losses, both in the fishery sector and in the tourism sector. Claims for property damage when the oil cover, obviously, property, and claims for the measures to reinstate the environment. And again, in the next webinar, we're going to talk more in details about these types of claims, but this is just to give you an idea of what is covered by the conventions. The way it works in tiers. So the system applies in the same way, but different entities pay different levels. So the first level, which is governed by the Civil Liability Convention, it is the ship owners who pay compensation through insurance, and then in fact they pay insurance to the insurer, normally P&I club, and the insurer will pay compensation to the claimants. With the 92 convention and the supplementary fund convention, it works slightly differently. It is the receivers of oil in the member states which pay for a compensation, but they do not pay directly. They pay a contribution, which is calculated based on the amount of oil received every year. This contribution is paid into the fund, the organization, and the 92 fund pays compensation to the claimants. And it's the same for the supplementary fund, with an exception that I'm going to talk about in a couple of slides. The first tier, Jan has already spoken about it, so I will just go very quickly. Basically, the ship owner is liable with unfault, strict liability. The claimants, the victims, do not have to prove fault; they have to prove their loss. They are entitled to they have the right to limit liability based on the gross tonnage of the ship, but they have to have insurance to make sure that they actually can make the payment. There are very few exceptions to liability, and it's basically if the damage has resulted from an act of war or a major natural disaster. If the damage was a result of sabotage of an intentional act by a third party, and if the damage was caused by negligence or a wrongful act of a public authority. On the other hand, they cannot limit liability if the damage was caused by the owner himself or herself with intent or with knowledge that the damage could occur. So it's as you can see, the liability is very strict, the exceptions are very strict, and also how the limit can be broken is also very strict. Going into what the fund does, the fund pays compensation when the damage exceeds the liability under the CLC, or if the ship owner cannot meet their obligation, they don't have money, or if there is no liability under the CLC. The maximum amount available for compensation is 203 million SDR, which includes also the amount available for compensation under the CLC, so it's not on top of it. That is about 287 million US dollars. Like I said earlier, the contributions come from the receivers of the oil in the states. So it's not the states who pay, but the oil receivers. And there are even, there is basically just one big exception, well, two. One, if it's the damage is caused by an act of war, the fund is not liable to pay. And if the claimant cannot prove that the damage has resulted from a ship, from an incident involving a ship, so a tanker, basically, as defined by the convention. There is a third tier. Like I said, the third tier works just about the same way as the second tier, with two main differences. One is that the amount available for compensation is much higher. So the third tier comes into place when there is not enough money available under the 92 Fund Convention. The amount available for compensation is about $1 billion US, which includes the amount available under the 92 Fund and the amount available under the CLC. And the contribution is again from the oil receivers and the state party. However, because the amount is so high, at the diplomatic conference, it was decided that there is a minimum contribution that is estimated for each member of the supplementary fund. This minimum contribution is 1 million tons of oil, which basically means that if you do not have enough receivers in your state, in your country, to receive 1 million tons of oil, the difference will have to be paid by the government, or by the state anyway. So there is a bit of payment. The 92 fund is, let's say, free to join for a state. The supplementary fund might have a bit of payment to be made. This is in graphic terms what the compensation looks like, liability looks like under the system. As you can see, the CLC has a sliding level. It goes from 4.5 million SDRs, which is about 7 million US dollars, to 127 US dollars based on tonnage. And then on top of that, you have the 92 fund, so 287 million US dollars. And then on top of that, you have the supplementary fund, which is, like I said, 1 billion US dollars. Now, if we look at the GI WACAF region, you can see the majority of the member states, or the states and the GI WACAF, are members of the fund. So they're covered by the CLC and Fund Convention. Only Congo is also a member of the Supplementary Fund Protocol, which means that if there is an incident in Congo, victims will have access to up to $1 billion. Just to be clear, the fact that there is so much money available doesn't mean that it's going to be spent on the incident. The claims will still be assessed, and we will have to decide whether the claims are reasonable. If there is you see, there are some countries you can see on the right of the image or the map that are not members of the fund. That means that they will have access to much lower amounts for compensation if there is an incident, or in the case of DRC and Guinea-Bissau, there is no convention in place. So it's something that you should really consider to do, is to look into ratifying at least the 92 Fund Convention. Like I said, it doesn't have financial burden on the state. There are administrative burdens for implementation and everything, but no financial burden. And it's very important because if you have an incident, say an incident between two countries, one of which is 92 Fund, not one of which is only 92 CLC, the victims in the two countries will share the amount available under the CLC, but only the victims in one of the country, there's a member of the 92 Fund, will receive compensation under the 92 Fund. In terms of time bar, liability doesn't remain for everything. You don't have the right to receive compensation lasts only for a limited period of time under the CLC and Fund Convention, and that is very similar to what other most of the other liability conventions have. It is 3 years from the date of the damage. And in any case, there's no more than 6 years from the date of the incident, in case the damage happened a bit after the incident. If you do not submit a claim and reach a settlement with the fund or the insurer within these 3 years or 6 years, then you lose the right to receive compensation unless you start legal action against the fund and the insurer. Having said that, apart from one notable exception, in the fund history, more than 95% of the claim, 90% of the claims have been resolved within 3 years from the date of the damage. And only a very small minority of claims had to go to court to extend the time for which compensation could be, settlement could be reached in an amicable way. So to conclude, and I think I'm definitely within the time, you can confirm. The system has been in place for over 40 years. This data that in this slide is only for the funds. Obviously, the clubs have paid compensation to a lot more incidents, smaller incidents. The funds normally deal with very large incidents. But we have paid over $1 billion in compensation for more than 156 incidents. Like Jan said, the system has been used as a model for other liability conventions. It works fairly well. And as you can see, for the fact that most of the countries represented today are members, and I'm sure if they have a problem, they will tell me during the questions. But anyway, that is how the compensation regime works for oil pollution. Thank you.
Thank you very much, Chiara. I think we'll do the same as for Jan, meaning that we'll go over your 2 quiz questions after the very last presentation, so that we make sure that David has enough time to cover his presentation. Thank you very much, Chiara, and David, the floor is yours.
Thank you, Chloe, and good afternoon, everybody. So without further ado, the last presentation of this afternoon in this webinar. And as part of this last presentation, I'll be covering 2 matters. I'll give a very brief run through the role of P&I clubs and the scope of the insurance cover that the P&I clubs provide. And as part of that brief overview, I'll also touch on the international group of P&I clubs who I work for. We'll then move straight on to the International Convention on Civil Liability for Bunker Oil Pollution Damage 2001, the Bunkers Convention, that Jan has briefly touched on in his presentation. The international regime governing liability and compensation for pollution damage from ships' bunker oil. We'll talk about the key provisions, the insurance requirements, the financial guarantee certificates under the Bunkers Convention. the role of the P&I clubs underpinning that particular IMO regime, and then we'll talk about the right of an owner's limitation of liability under the Bunkers Convention, and how, as Jan has mentioned, that is linked
That
to
is Rob's
LLMC.
He told me it was fine the day. He has no
Sorry, and then we'll conclude with a summary. Okay, so what are P&I clubs, protection and indemnity clubs? Well, in short, they're insurance companies, and they insure third-party liabilities relating to the use and operation of ships. And the insurance cover that they provide is called P&I cover, P&I standing for protection and indemnity. And what does that insurance cover include? Well, P&I cover that the P&I clubs provide, it incorporates insurance cover for losses, claims, damages arising from ship source pollution damage, including, importantly for this webinar, oil pollution damage. And that includes where the oil pollution stems from oil carried as cargo, or whether it is ships' bunker fuel oil. That P&I insurance cover that the clubs provide, it also includes cover for death and personal injury to passengers and crew on board ships, damage to fixed and floating objects. So if a ship coming into port, it hits a terminal, it hits a wharf or a gantry crane or a pier, the P&I cover includes losses arising from such damage. That P&I cover also covers wreck removal and loss or damage to cargo. It is not insurance cover for damage to the ship's hull or any machinery on board the ship. That insurance cover, H&M cover, is provided by separate insurance underwriters. So what is the international group of P&I clubs? Well, the international group of P&I clubs incorporates 13 of the major P&I clubs worldwide. And when those 13 clubs collectively come together as one, they provide insurance cover to over 90% of the world's ocean-going tonnage, something in the region of 1.21 billion gross tons of shipping. It's about 65,000 vessels in total that have their P&I cover with one of these 13 international group clubs. And that includes over 95% of all ocean-going tankers. There are P&I providers outside of the international group of P&I clubs, and they are generally providing P&I insurance cover in the small ship sector. These are the logos of the 13 international group clubs on the screen here. 8 of those 13 P&I clubs are headquartered in the United Kingdom. 2 are headquartered in Norway, 1 in the United States of America, and 1 in Japan, although they all have regional offices around the globe in order to service their ship owner members. So let's move straight on to the Bunkers Convention, the convention that was adopted by the IMO in 2001, governing liability and compensation for pollution damage from ships' bunker fuel oil. That convention entered into force in 2008, and there are currently 102 states parties to that convention worldwide. And you can see those states that have ratified or acceded to the convention that I've highlighted on the screen here in yellow. Most of the European states are party to the convention, a large number in East Asia, Australasia, Canada, a few in Latin America, and a relatively small number in Africa and West and Central Africa. And hopefully, through this presentation, we can explain the benefits of the convention itself, so that if it is not in force in your country, it is something that you will very closely look at implementing and acceding to. So what are the key provisions of the Bunkers Convention? Well, the Bunkers Convention, the key provisions are very similar to the key provisions of the 1992 Civil Liability Convention, CLC, that Chiara has just explained. The Bunkers Convention applies to spills of bunker oil that is defined in the convention from all types of ships, except CLC tankers where they are carrying a persistent oil cargo that Chiara explained in her presentation. The Bunkers Convention governs liability and compensation for pollution damage arising from a spill of ship's bunker oil, and pollution damage itself is also defined in the Bunkers Convention. And that definition as to what pollution damage incorporates and encompasses is almost identical to the same definition of pollution damage in the CLC. The Bunkers Convention imposes strict liability on the ship owner for pollution damage. Same as CLC in terms of strict liability, so liability irrespective of fault, save for a few exceptions. But that strict liability on the ship owner in the Bunkers Convention, ship owner is actually defined as including the registered owner, bareboat charterer, manager, and operator of the ship. All of those parties are jointly and severally liable on a strict liability basis for pollution damage under the Bunkers Convention. That is different to CLC, that imposes strict liability for pollution damage arising from the carriage of persistent oil cargoes only on the owner. Whereas here you can see that there are a number of parties that are strictly liable under the Bunkers Convention. As to what pollution damage they would be liable for, well, as I mentioned, the definition of pollution damage is almost identical to the same definition in CLC. So we would expect that the ship owner would be liable for the same pollution damage under the Bunkers Convention. Preventive measures, cleanup costs, damage to property, economic loss caused by contamination, restoration costs of the environment, etc. Very similar to CLC we would expect in that regard. The geographical scope of the Bunkers Convention is also the same as the CLC, and it applies in a state's territory, territorial waters, and EEZ or equivalent area where a state ratifies or accedes to the convention, and preventive measures wherever they are taken, including outside of a state party's EEZ or equivalent area. Again, the same as the 1992 Civil Liability Convention. However, in the Bunkers Convention, and Jan touched on this in his presentation, there is no limitation regime for the ship owner. The Bunkers Convention itself does not establish the financial amounts up to which the ship owner will be liable. That is dependent on national law or a separate global limitation regime such as LLMC if a state party to the Bunkers Convention has ratified or exceeded any such separate global limitation regime such as LLMC. And I'll come back to that in a few slides' time. There is no additional compensation fund such as the IOPC fund or its supplementary fund sitting on top of the Bunkers Convention. It is the Bunkers Convention alone with a single tier of liability on the ship owner for pollution damage. No IOPC fund sitting on top of the Bunkers Convention that you have with the 1992 CLC. There is a compulsory insurance financial security requirement in the Bunkers Convention, and the convention requires all ships above 1,000 gross tons to maintain financial security, and the financial amount of that insurance is always limited to the ship's equivalent limit of liability under the 1996 LLMC protocol, whether that is in force or not. But the convention only requires the registered owner to maintain that financial security. None of the other parties that are strictly liable under the definition of ship owner are required in the convention to maintain financial security. It is only the registered owner that is required to maintain that insurance for their ships under the convention. As with CLC, as Chiara mentioned, where a claimant incurs or suffers pollution damage, they have a right under the convention to bring their claim directly against the provider of the ship's financial security. And that will normally be a P&I club, the ship's insurer. Under the convention, all ships that fall under the insurance requirements are required to carry on board a convention certificate issued by a state party, normally the state of the ship's registry, if it is a party to the convention, and that certificate is carried on board at all times to evidence that that ship has convention insurance cover in place. States issue those certificates to ships upon receiving a Bunkers Convention insurance certificate, more commonly known as a blue card, that is issued by the ship's P&I club to the registered owner. So the registered owner obtains a Bunkers Convention insurance blue card from their P&I club for their ship. They submit that blue card to the state party ship registry to the convention, and that state party, upon receiving that blue card, will issue their state convention certificate for that ship that is carried on board at all times and presented to port state control when that ship is entering the port of a state party, evidencing that that ship has insurance cover in place. The International Group of P&I Clubs has established an online means of verifying the authenticity of these insurance blue cards that are issued for the purposes of the Bunkers Convention. If you go on the International Group of P&I Clubs website, they have a ship search facility that is publicly accessible and updated every 24 hours, and it looks like this on the screen here. You type in the name of the ship that appears on the Bunkers Convention insurance blue card, and I've given you an example here of a particular ship that is entered with one of the international group clubs, the West of England Club. It's the Sea Beauty ship. That ship search facility will then tell you which club that ship has its P&I cover with. And the name of the ship will then provide a hyperlink through to that ship's P&I club, and that will then tell you whether that ship has been issued with a Bunkers Convention blue card. And that is the means of authenticating whether a blue card has been issued by an international group club or not. So why are the P&I clubs of relevance to the Bunkers Convention? Well, they provide the insurance cover that the convention requires. And given that the international group clubs provide P&I cover to over 90% of the world's ocean-going tonnage, most oil spills and most going ships' bunkers will involve a ship that has P&I cover with one of these 13 international group clubs. Although the P&I clubs provide P&I cover for pollution damage as of right and as part of the standard P&I cover that the clubs provide. And that cover for oil pollution damage is not dependent on the Bunkers Convention being in force or any other IMO convention being in force. The clubs provide that cover for oil pollution damage as part of their standard P&I cover anyway. And it is the clubs that handle, assess, and pay Bunker Convention claims. As I mentioned, there is no involvement of other parties such as the IOPC Fund, And it is the clubs that issue the Bunkers Convention insurance certificates, the blue cards, that allow states to then issue the state convention certificates that are carried on board. So I mentioned earlier, and Jan also mentioned, that there is no dedicated limitation of liability regime in the Bunkers Convention. The Bunkers Convention does not set out the financial amount that the ship owner is liable for in the event of ship source pollution damage from ships' bunker fuel oil. And in order to understand how a ship owner's right to limit liability works, we need to look at Article 6 of the Bunkers Convention. And this is what Article 6 of the Bunkers Convention says. Nothing in this convention shall affect the right of the ship owner and the person providing insurance or financial security to limit their liability under any applicable national or international regime, such as the 1976 LLMC Convention or its 1996 LLMC Protocol. And on Article 2 of the 1976 LLMC Convention allows a ship owner to limit their liability for claims, including claims in respect of damage to property and claims in respect of anything that is or has been on board such ship. And that would include pollution damage claims arising from ships' bunker fuel oil. Now, I just wanted to show what that equates to in relation to the financial amounts that the ship owner would be liable for in the event of a bunker convention case where there is oil pollution damage from ships' bunker fuel, and the 1996 LLMC protocol is also in force in that state party. And as Jan mentioned, the highest limits of liability that are available under the LLMC regime are contained in the 1996 LLMC protocol. And the limits of liability under that protocol are dependent on the size of the ship. The larger the ship, the higher the limit of liability, and therefore the higher the financial amount that the ship owner would be liable for under the Bunkers Convention, where the 1996 LLMC protocol is also in force. And I've just tried to show these financial amounts under the 96 protocol on the screen here for different ship sizes, from 2,000 gross tons going along the x-axis to 175,000 gross tons, and both in SDR millions, which is in blue, and also in US dollars millions, which is in grey. For a ship of 2,000 gross tons, the ship owner's limit of liability under the 1996 LLMC protocol for bunker oil pollution damage would be something in the region of 1.4 million US dollars. That goes up to approximately 4 million US dollars for a ship of 5,000 gross tons, approximately 8 million US dollars for a ship of 10,000 gross tons, and then going up to 95 million US dollars approximately for a ship of 175,000 gross tons. So what are the key differences between the Bunkers Convention and the 1992 CLC fund system? Well, as we've mentioned, the main difference is that there is no IOPC fund supplementary fund as additional compensation available above the owner's limit of liability under the Bunkers Convention. It is only the ship owner, their P&I club, with ITOT's assistance, that handle and assess and pay Bunker Convention claims. No fund involvement at all. So in summary, why is the Bunkers Convention important? It is the only international regime governing liability and compensation for pollution damage caused by spills of oil from ships' bunkers. There was no previous global regime governing such liability and compensation prior to 2001. its objectives are very much the same as CLC Fund, though, as Chiara has set out. And where the convention is in force, it should ensure that where there is pollution damage and there are claimants who have suffered losses, then it should provide that there are amicable settlement of claims, avoiding lengthy and costly court involvement. And the key provisions there are strict liability of the ship owner and rights of direct action against the insurer to try and avoid any need for claimants going through court processes with their claims. When the convention is widely ratified, and the Bunkers Convention is, then its application should be uniform across the globe. And that is important for claimants, ship owners and insurers, all of whom need certainty in the event of an incident. And it should also mean, as Chiara mentioned with regard to CLC Fund, that everyone gets treated equally. But the Bunkers Convention is incredibly important for coastal and port states because there are many more spills of oil from ships' bunkers than from oil when carried by sea as cargo. And as I've explained in relation to the financial amounts that a ship owner would be liable for under the Bunkers Convention, it's incredibly important that when states are looking at ratifying or acceding to the Bunkers Convention, they also ratify or exceed the most up-to-date LLMC limitation regime, which is the 1996 LLMC protocol. Thank you very much. That's a very quick run through. Happy to answer any questions. Chloe, back over to yourself.
Thank you very much, David. So we have a couple of minutes left. So what I suggest is to go back to the quiz questions from Jan first and then Chiara, so that the audience gets a chance to interact with the speakers. So let me start the first poll, which was Jan's first question. Which conventions were adopted in 1969? The Civil Liability Convention and Fund Convention, or the Civil Liability Convention and Intervention Convention, or the Fund Convention and Bunkers Convention, or the Intervention Convention and Bunkers Convention. You can access this webinar, this poll, sorry, which should appear under the chat box at the bottom right of your screen. I see a couple of participants that have already answered, so I'll leave you a few minutes more to answer this question. Jan, can you see the results of the poll in the webinar window? I think you can unshare your screen.
Sorry, Chloe.
Yes.
I cannot stop sharing now the screen. I don't know what's happening.
You need to go back to the webinar window and click on turn screen share off.
I know, but it doesn't work. I cannot get there. It's impossible. Let me check.
Here we go. I can do it.
Okay. Thank you very much. So you wanted to
yes,
go meet to a poll? Yeah?
Yes.
I'm
ending the poll so that you can see and comment the results.
Yeah, well, the correct answer is the second answer. The Civil Liability Convention and the Intervention Convention were established in 1969. So, yeah, it's not the majority of responses, but it's quite competing with the logic answer, of course, the Civil Liability Convention and the Fund Convention. But the Civil Liability Convention was established in 1969 and the Fund Convention in 1971. So that's definitely not adopted at the same conferences. And the Bunkers Convention was adopted in 2001, and the that makes the third and the fourth alternative responses impossible. So I'm happy with the result that at least there is a competition between two possible responses. Thank you for that.
We'll take a very last question before we need to end this webinar. So I don't know which of you presenters want to answer this one, but the question is, what happens when a state fails to ratify the CLC Convention?
Thank you, Chloe. I'm happy to have a go at it, and if Chiara and Jan would like to add anything. It's a very good question, but what it would mean is when those who suffer pollution damage arising from the carriage of persistent oil as cargo, then they would not have the ability to hold the ship owner strictly liable. They would not have rights of direct action against the P&I club providing the insurance to that particular ship. So if in such a circumstance a claimant has incurred losses arising from an oil tanker incident and their state has not ratified the Civil Liability Convention, they will find it very difficult to recover those losses other than to go through a very lengthy court process. The same would apply to the state itself. If a state incurs costs in terms of responding to an incident, an oil tanker incident, where it's a persistent oil cargo and they haven't ratified the Civil Liability Convention, that state will also find it very difficult to recover those costs from the ship owner and may also have to go through a lengthy court process to recover anything at all. As we said in relation to bunkers and CLC, the objectives of those conventions is to avoid such lengthy and protracted and costly court action because the ship owner would be held strictly liable. No claimant would have to prove that the ship owner is at fault, and claimants can bring their claims directly against the insurance company. So it makes it much, much easier to recover losses where there is damage in the event of an oil tanker incident where CLC is in force. I hope that answers the question.
I think so. Many thanks to all of you. We'll have to close the webinar here since we already ran out of time. So I want to thank all the presenters for their high quality presentations. I also thank my colleague Lindsay, who worked with us on the organization of this webinar. And finally, thank you all for attending this webinar and engaging with us. Do not hesitate to register to our next webinar on October the 13th on how to claim for compensation in case of no spill. Registration links are already on our website. And thank you again to all of you. I wish you a nice rest of the day and see you soon. Goodbye.
Thank you. Bye-bye.
Bye. Thanks.
Bye.
Thank you. Bye-bye.